Okay, good afternoon. Today is April 18th, 2012. We talked about fresh complaint of rape. We talked a little bit about the state of mind exception, the medical diagnosis and treatment exception, of course the child hearsay exception. One of the things that Myers talks about, and it's really critical, I'm not going to spend a lot of time on it here, but it really is critical if you're a child advocate and you learn information about abuse or neglect from a child or from people around the child, and that is the simple concept of documentation. You need to document what you see, what you hear, what you sense, and you need to document it well in effective, clear, unambiguous language. And that is a 12-week course, if you ask me. It really is. To be really good at writing. And writing requires being really good at observing and understanding what's relevant. So we got a little taste of it last week when I said to you, and I now remember where we ended, when I said to you, take a look at the Law and Order clip. It's obvious she's excited. That's the man. That's the man. He was wearing a green jacket. He ran down 9th and Cooper. We all agreed she was jacked up or excited or nervous or agitated. But the thing I wanted from you, and you helped me a lot, you did really well, I said, what makes you say that? What about her is agitated or excited or nervous? Because in order for that information to come in as an excited utterance, an exception to the hearsay rule, we need to demonstrate why it's an exception, why it ought to come in, why she didn't have time to reflect, why this was an excited utterance. And you told me that her voice was going in and out, she was shaking a little bit, she was flailing her hands and arms. Her earrings, I pointed out, were swinging in the wind because her head was bobbing. Her cadence was different, her voice was shrill and high-pitched. That's good information. When you say, oh, the lady was really excited when she was pointing, she was really jacked up, okay, those are conclusions. That's your opinion. What we need are facts that led you to conclude that. Sometimes police officers or investigators or detectives will say, I just have a gut reaction. It's in my gut. I think he did this, or I think he did that, or I just feel it, or there's mother's intuition. Well, let me disabuse you of something. There's nothing in this world but science, okay? People don't have extrasensory perception. People just don't know stuff because they have a sixth sense or a special ability or some kind of mystical talent, okay? Now, you've got a right to believe that, but it's not true. It's what I believe. Thank God I'm in an academic institution. And I'm telling you that the cop who says it was my intuition, or the mothers know these things, or the detective who says I just got a gut instinct, if you cross-examine them, and maybe that's the wrong word because that suggests challenging them, or being assertive, or being argumentative. If you question them thoroughly about what makes them say that, you would find facts that support their belief that he's a drug addict, or he beats his wife, or she killed him for insurance. You know, I just got this feeling. Sit down with me or an accomplished interviewer or attorney, litigator, courtroom attorney, for 10 or 15 minutes, and I'll figure out why you came to that conclusion. And it's not because you're special. You may be special because you're good at observing and good at determining facts that are relevant and putting them in your brain. You may be special in that way, but I mean you're not biologically special. You know, you're not someone who has a sixth sense or some mystical talent that allows you to discern these things. It's because you saw things and drew reasonable inferences from them. And I will tease them out from you. Similarly, when you are in the field or you are making observations about kids or people or principals or daycare center owners or psychologists or whomever, if you're interacting on behalf of a child, if you're advocating on behalf of a child, and you are drawing conclusions about what you've learned and about the people you meet and about what may have happened to this child, you need to document that later so that you can refer back to it. And this is more for investigators and forensic interviewers and detectives and child protection workers that go out and do investigative work. You need to document that. And a little peek into good documentation was telling me why that woman was agitated. Don't tell me she's agitated. Don't tell me she's anxious. Don't tell me she's nervous. Tell me what her behavior was. What did she do to lead you to conclude that? Remember that, and you'll be a good investigator or documentator. There's no such word. I don't know what the word is, but you know what I mean. You'll be good at documentation. If you've ever seen, and you really have no reason to see this happen, but I'll tell you because I'm in law enforcement, the best witnesses for telling what the behaviors were or what the observations were that led them to a conclusion are state police officers that work, okay, patrol detail. Because they pull over lots of people at 3 and 4 in the morning driving how? What do some people do that gets them in trouble? Well, driving erratically is good information to draw a conclusion, but what are they probably, what state are they probably in? Drunk, intoxicated. So an inexperienced state trooper right out of the academy will take a witness stand and go, what happened? The lady got out of the car. What happened next? She was drunk. She was intoxicated. She was impaired. Okay. What makes you say that, right? Those are conclusions. To say someone's intoxicated, to say someone's impaired, to say someone is drunk, to say someone was high, to say any of those things are conclusions. That's a good start. I'm not telling you not to draw those conclusions. That cop did a good thing. You know, he pulled the car over and he looked at the person and said to himself or herself, I'm not going to let them back in the car. This person's drunk. But they made that determination based upon objective facts and behaviors and information. And they get good at saying that because judges ain't going to accept that. They want to know what makes you say that. What are the facts upon which you drew that conclusion? Same thing like the nervous lady, the drunken person, and I said there's no better person to express and document the observed behaviors that support a conclusion than a state police officer on the witness stand in a drunk driving case. Go ahead.
Before they used to make people walk on a line, but I think now they use those things where you blow air into the machine. I forgot the name of it.
The breathalyzer.
The breathalyzer, there you go. Isn't that fact enough?
Well,
It's hot.
yes and no. You cannot make anybody take a breathalyzer, right? So you need some modicum of drunkenness to even bring out the breathalyzer. So evaluating behavior is still highly relevant in this era of high tech, where they blow into a machine and it tells you their blood alcohol level or their blood alcohol content. That's why they do both. They still do both. They call those generally dexterity tests, and there's other descriptions and characterizations of them. There are a variety of them. Some have gone out of favor, some are in favor. But those kinds of dexterity tests are used in conjunction with the blood alcohol evaluation. And, you know, what if the blood alcohol finding is high, but the person took NyQuil or had some other bizarre thing? They got in a health food store in New York that kind of skewed it, and you know, you want to use as much information as possible to convince a judge that they're drunk. So you use both. Now I don't know if those are good defenses or not, but you don't want to rely solely on a machine. Go ahead.
Oh yeah, I was going to ask, is it like once you have a license, an officer has the right to ask you to take a breathalyzer? Isn't it like some sort of law, and then once you refuse, they just take you to custody?
You have a right to refuse. I mean, let me say that the right way. You don't have a right to refuse a breathalyzer. I am no expert on drunk driving law. I suspect that the standard for asking someone to take a breathalyzer test is very, very low. The threshold is very low. The standard is not that significant, which is sounds like what you're saying. And the rationale is because driving is a privilege and whatever. I don't know. I'm listening to what you say and thinking about it. But there always has to be some threshold before you can whip out a machine. It makes, I don't care if driving is a privilege. And the reason is so then you pull over every black person and make them blow a breath. Well, they have the privilege to drive, you know, so the anti-discrimination laws are invoked, right? You can't just make people take the breathalyzer. Obviously, if you go after a certain class or do it in a discriminatory way, that's a major problem, right? You can't do that. The breathalyzer, I would think that you need some basis to use it. However, you know what? They were driving erratically. But I can look that up, you know. But you can't be arbitrary. And if you worry about being arbitrary, then you need some basis, right? The government, the standard for doing anything in government is not to be arbitrary. Arbitrary is bad. Arbitrary means I did it because I felt like it. But the government don't work that way. I did it, that's what I do. Every blue car I do, because I didn't like blue cars when I was a kid. You can't act like that. There has to be some basis, even for things that you really don't need much to do, which is probably making them do the breathalyzer. But back to the cop on the stand. She would testify, the trooper would testify about what she observed. And she'd say the target's eyes were watery. He had an unsteady gait. I would probably say, well, what does that mean? Well, he was wobbling. He couldn't stand up. At one time he fell. I helped him get up. I made him walk heel to toe in the standard blah, blah, blah. He couldn't make it heel to toe. His speech was slurred. He smelled of the odor of alcohol. I smelled marijuana emanating from the car. These kinds of objective facts that support the conclusion. So that's what documentation is all about. Good documentation. Like I said, you spend 12 weeks, but you really want to write down what it is that brings you to that conclusion. Okay? In the world of child abuse and child advocacy, there may be a situation where a kid makes an excited statement. Or they're going to the doctor. We talked about how we need to document things. The child needs to know that they're going to be treated. They have to want to be treated. And they have to make statements that are for the purpose of being treated. So you need to write that down. What was said to the kid, what the kid said. Simply say, I treated the kid for vaginal trauma. And I questioned her about what happened, and she told me. Is not enough to get the hearsay exception. If she said to the doctor, will I be able to have babies one day? I'm sure you will, but we're going to check you out and make sure you're okay. So I need you to do this for me. What about diseases I saw a program on TV? You need to document that, right? Documentation is important. If you leave that out, then we don't know that that child had a treatment motive. Professor Myers talks about multidisciplinary teams, and I will mention them briefly, but there are two kinds of multidisciplinary teams. Well, they're actually the same team in a way, but they're responsible for two different kinds of child advocacy. One is case management, and one is investigating cases of child maltreatment. So what's a multidisciplinary team? Well, if we look at the term, multi, many, disciplinary, involves different disciplines. Team, a collection of people who have the same goal, right? So in child maltreatment, it was decided some time ago that because there's so many different disciplines, so many different entities and institutions, and advocacy groups, and child protection groups that are interested in child welfare, that maybe we ought to get these groups together and meet regularly to make sure that these kids are being treated properly. that they're not getting a duplication of services, that they're getting the right services, and they're not missing out on services. So the team typically in many communities consists of law enforcement, medicine, psychology, child protection, and prosecution. Those are the typical team members. Law enforcement, medicine, psychology, child protection, prosecution. Did I miss one again second time?
There's 5, right?
Well, this is typical. It could be 10, it could be 3. It depends on the community. If you're in Decatur, Georgia, it might be a smaller group. DIFUS, or child protection. When I said they do case management, I'll tell you what the word means. Every 2 weeks, they meet in a conference room, around a conference table. And they have an agenda. They have 20 cases involving 20 kids. One kid got burned by her father. The other kid got molested by her uncle. The third kid's mother let her drown. The fourth kid, it's a homicide. The fifth kid is... So this is the case. They have an agenda. And at the table is DIFUS worker, child protection, a representative of St. Joseph's Hospital, a representative, this is in Passaic County, by the way, a representative of St. Joseph's Hospital in Patterson, a representative of Hackensack University Medical Center in Hackensack, psychologist from Hackensack University Medical Center, DIFUS supervisors, prosecutors, and a detective from the community. And we talk about the cases. You know, we charge, typical discussion is something like this. You know, that case where the uncle molested the girl and he was visiting from Sicily? Yeah, well, we charged him. Did you know that? No, I didn't know you charged him. I knew you were investigating it. The DIFUS worker writes it down. The lady from St. Joseph's Hospital goes, oh, I knew they charged him because I was here that day and delivered some medical records. By the way, did the kid get the medical exam? No, the parents didn't show up. So I called DIFUS. DIFUS goes, yeah, they called me, and I talked to them, and it was a legitimate excuse. But we rescheduled for the following Tuesday. Prosecutor says, you know what? Let me know how that works out, because I need to get some medical diagnosis and treatment exception evidence in, maybe. So make sure that kid understands, you know, that she's going to be treated to make sure she's well and that she can function normally and she's healthy. So the group who are doing all different things, the hospital just wants to treat the girl. They can go on their merry way and not talk to us, but that's not good for kids, right? Child protection could just worry about whether the kid's safe. No, we took the father out. He's got to live with his sister in Kenilworth. Our job's done. You can look at it that myopically, that narrowly, that blindly. Or you can look at a kid as having many advocates. And all those advocates need to communicate with one another to get the best possible outcome. That's what the multidisciplinary team does. That's the team working as case management. That's when the case has already been charged or we're already involved. It's looking at the administration that surrounds this kid, rather than the investigation. Now, multidisciplinary teams can act as an investigator, too. To show you, and I kind of put what's second in time first, and that's the administrative discussion at the conference table. The investigation worked in a multidisciplinary team way as well. I'll give you an example of a case that had an excited utterance, and I'm looking forward to listening to the 911 tape. It's sad. It's a child who was molested. But from an academic perspective, I'm interested in the 911 tape. And you don't get a lot of 911s. I played you a little bit of a 911 call last week from a 9-year-old girl. It's rare. But I think more kids are learning about 911 and more kids are using it than they used to maybe 5, 10, 20 years ago. But anyway, ideally this case should have unfolded like this. The girl says that her uncle came in the bedroom. No, it's her stepfather. And he was masturbating while she slept. And she opens her eyes and she sees him there. And she freaks out and yells at him. And he's like, whatever. Who knows how he reacted. I don't have the paperwork yet. But she ran into her closet and dialed 911 on her cell phone. Now, the girl's 14. So she dials 911 on the cell phone. What should have happened was the police that got that call should have called the prosecutor's office. We should have called the Division of Youth and Family Services. That kid should have been brought immediately to the Child Advocacy Center for a forensic interview. Okay? The mother should have accompanied her as her guardian. And the uncle, no, it wasn't the uncle, it was the stepfather. The stepfather, based upon what we know, would have been seized as well. He would have been taken into custody and brought to the police station. Well, we would take them in our county to the prosecutor's office, but to a law enforcement space. And DYFS, the municipal police, this was in Wayne, New Jersey, the Wayne police, DYFS, and the prosecutor's detectives, as well as the forensic interviewer, are all involved in the case, all involved in the investigation. Now, if that girl needed a medical evaluation, in this kind of case, it's one of the rare cases where we probably would not get a medical evaluation, but we would, at that point, we would make those arrangements, and the St. Joseph's Hospital or Hackensack Hospital would be notified, and the next day the kid would go there. So that's the teamwork in investigating the case. Same kind of group, but we're doing stuff. We're investigating. 3 weeks to a month later, that case is unfortunately ancient history in our world, but it's not, because we're going to meet at that conference table, we're going to talk about the case. What happened? Did the guy give a confession? Did he deny it? Did we have a copy of the 911 call? Did the kid go to the doctor? Did she make new disclosures? Did she say this happened in the past? One of the interesting things we learned, which is not unusual, there was a prior report that this man did something to her, and no one heard of it. Prosecutor's office, municipal police. I don't know if DYFS heard of it and didn't tell us. I think they didn't tell us, but for some reason didn't think they had to tell us, or tried to tell us and were unsuccessful, or it wasn't that big a deal. I don't know, but there's evidence that this kid had made a prior report. Sometimes they make a report and an hour later they recant. You know? So I don't know what that was, but by working as a team, I learned that that happened. And as law enforcement, I need to know what happened. Did she say this and say I made it up in the past? That might impair her credibility for this allegation. Certainly needs to be shared and known. And by working together as a team, we learn that. Multidisciplinary team. That's the way child advocacy works in many communities in America nowadays. And it's a good thing. Professor Myers talks about some research that speaks about multidisciplinary teams and whether it works or not, and how well it works, and that's in your readings as well.
Professor, just to have this right, case management is when the multidisciplinary team gets together?
Yes, that's case management,
Professor?
as opposed to investigation. Multidisciplinary team investigation, multidisciplinary team case management. Yes.
I would respectfully say that I would have asked the child to get a medical exam, or I would at least explore that because of what may have happened before, in the past month or years, before he came into the room masturbating. If there was another call, or another complaint, maybe this is just the icing. This is the straw that broke the camel's back, and the child has been abused.
And I agree with you. The case came in, and I said it's exceedingly rare, feeling like, and that's intuition, but I'll tell you why. Because she was in the closet, she reacted immediately. Kids don't typically react immediately. That's even rarer. So that suggested to me that if she had the ability to react immediately and call, that this is probably a discrete single incident, non-contact. So it's, again, one of those real rare incidences where you might not get a medical exam. Many pediatricians argue that there should be a medical exam in all cases. I believe that clearly whenever there's contact, whatever it might be, a cheek grab, it doesn't matter to me. If in a sexual context some man has contact with a child, we need to get a medical exam. And many times kids hold back or minimize what happened, and we learn more. And it could have been far more intrusive to molest than it first appears. And in this case, you make an excellent point. There's evidence that there was a prior referral. But having said that, I need to see it all. I need to see what that for. Maybe the prior referral was mom didn't give her a jacket in the winter. I don't know what that was. But it is arguably good practice to get every kid who is assaulted by a man a full medical for wellness. They call that a wellness exam. But here you have almost a indecent exposure. So the question about whether you would do that is a little bit different. Now, the next thing Professor Myers talks about is videotaping interviews. Now, everywhere in New Jersey, we videotape interviews of children. And one of the big reasons is, and you've all learned about the tender years exception to the hearsay rule. Kids 12 and under, well, their out-of-court statements can be admitted in court to prove the truth. It's an exception to the hearsay rule. So that means the video recording could be admissible. And most of the time, if not always, is. And that is important and helpful. So in New Jersey, we record all video. We video record all child interviews.
All that are under 12 or all?
All that are under 12. Yes, thank you. All that are under 12. And the reasons we do will kind of explain why we draw the line at 12. But the reasons we do are, one, it may be admissible, and almost always is admissible under the tender years exception. So what? Well, the video is compelling. It does a nice job of documenting exactly what happened, right? It shows that child's demeanor, in other words, what her behavior was, what her emotions were, or his, at the time that the interview took place. There's no characterization of those emotions. You can see them with your eyes. So it documents the child's police statement perfectly. Exactly how it happened. And that's a good thing for everybody. It allows us to evaluate the quality of the interview. One of the biggest areas of concern is the influence of police or social worker questioning on the memories of kids, right? Suggestibility and leading questions and misleading questions. Well, again, the video recording is a near perfect document of what exactly happened. We don't have to guess. We know the questions and we know the answers. We can see and hear the kids. So it's very compelling. Videos are very compelling. They freeze the child in time and development. Because often the 10-year-old who tells the story of what happened comes to court for the first time in the trial when she's 13, 3 years later, maybe even 4 years later. By the time she's 14, she's a different kid. Her credibility, her impact on the jury's different. You know, a teenage girl and a 10-year-old girl are perceived, like it or not, differently by people and by jurors. So now we've frozen that child in time. And the jury gets to see her at 10 rather than 14. She'll be there at 14 as well, because it's not a substitute to video. It's not a substitute for testimony. It's a hearsay exception that complements the child's testimony. It's an addition to. So the video is an accurate history of what the kid said and what the interviewer asked, right? It's very compelling. It freezes the child in time. and development. It helps us analyze whether there were leading or suggestive questions. It also demonstrates for the jury the child's narrative. And the narrative simply means her story, her statement about what happened, in a way that's more child-friendly. And what I mean by that is, when kids come into a courtroom, any witness for that matter, but especially children, they tend to be wooden, awkward, stiff. Excuse me. By wooden, I mean stiff. Scared, anxious, awkward, soft-spoken, nervous, agitated. All those things that don't make for a good witness. Confidence, calm, speaking clearly, sitting straight, being informal. Kids just can't pull that off. Very rare you get a witness like that. When you do, as a prosecutor or a plaintiff's attorney, or defense attorney for that matter, it's a happy day. Because so much of litigation outcomes are based upon witness appeal and jury perceptions. So here, by video recording the child, you're getting that kid's statement in a non-hostile, child-friendly, comfortable environment. At a center, in a small room, sitting on the floor, talking to a lady in casual clothes. The complete opposite of that is a courtroom. There is no more formal or intimidating context in which to tell about yourself than in a courtroom. And worse yet, to tell about sexual behavior with your dad than in a courtroom. So the video, excuse me, is very helpful to the fact finder, the jury, or the judge, because it shows the kid telling their story, their narrative, in a much more comfortable environment. So you'll get more information, better information, more at ease information, and you can size up the kid a lot better. So there are many arguments for using a video camera. It can reduce the number of interviews. So if the prosecutor has to prepare for trial, they may have to interview the kid only once, because they can watch the video and get a lot of insight into what the kid said and how the kid's personality is. If a kid gets a psychological exam at the Audrey Hepburn Children's House, they can get a copy of the video and watch it and get a sense of that kid's level of development, how that kid feels about the abuse, how they tell about the abuse. So they'll be better prepared to talk to the kid. So the video may reduce the number of interviews, or to say it differently, reduce the amount of times the kid has to say their story. Because the professionals who need to hear it again, or need to hear it for the first time, can watch the video. And it may reduce by one or two the interactions. And certainly, it reduces the amount of time future interviewers have to spend with the child, because they can look at the video and get most of the story and most of a sense of who this kid is and what their personality is. Some argue excuse me. Some argue that the video will reduce recantations, that kids will be less likely to take it back if it's recorded. Okay? You can also show the video to one of these caregivers, one of these mothers, who doesn't believe the abuse occurred or supports the actor. Now, you have to do it in the right way, in the right context, but it could help. That's a good thing about video recording. You show them a snippet where the kid is particularly compelling, and it might convince the mother. Similarly, the suspect might be convinced to confess. or to plead, or to admit guilt. Because the kid is telling their story in a natural, comfortable, and often compelling way. And it's on video. So you can show it to the mother, you can show it to a lot of people. If you show it to the bad guy, the accused bad guy, maybe he'll confess. You show it to the mother, maybe she'll change her mind about her daughter. It all goes back to, it's a video, and it's a good way to document stuff. Later on, it might refresh a kid's memory as they prepare for trial. Expert witnesses could use the videotape to prepare to give expert testimony. If there's an expert witness about the quality of the forensic interview or about the competence of the child under RW. We talked about RW first half of the year. The expert could take a look at the video and make some conclusions. Those are the arguments for video recording. There are a number of arguments against video recording. We know that kids are inconsistent at times. And sometimes it's because they're inconsistent, or sometimes they're not inconsistent at all. They just appear inconsistent when we ask a question that had a different meaning from the original question. But whatever it is, if kids are inconsistent, sometimes the inconsistency on the videotape may be exaggerated. Let's say there was a question about whether the guy put his penis in the buttocks or the butt of the child. Serious offense, quite different from rubbing her chest. More intrusive and more significant. Suppose that in the video interview, the interviewer thought that she labeled the buttock as bum, but the kid actually said butt. And maybe the interviewer was from England, where they call the butt the bum, I think. I don't know. But instead of saying, and was there a time that he put any part of his body on your bum? And the kid says, no. Now forget about that. It's not really a leading question. It would be appropriate in the right time in the interview. The kid says no. But later, when she's interviewed by the psychologist or the doctor, she says he put it in my butt. Now, we would say, well, that was a mess up. Later, she told Dr. Sands he put it in my butt and checked her butt. Although there were no findings, he couldn't rule it out. But all we get from Dr. Sands is what he says. But when she says, no one put anything in my butt, no. And the interviewer maybe even pointed to the butt. The kid goes, no, nothing like that. Thinking that bum meant something else. Right? So there's an inconsistency. Well, the video, you live by the sword, you die by the sword. The video is compelling, and it's a very good account. And the thing we documented on video was her denying any kind of anal penetration or anal contact. Yeah, we got Dr. Sands saying something different, but when you compare his recollection, his hearsay statement of what the kid said, compared to the video of the kid denying it, the video is arguably more compelling. So as Myers says, videotaping places, the video is exaggerated. It places exaggerated emphasis on inconsistencies in the child's description of abuse. So the video is compelling, and when the kid messes up, it's still compelling. So even though we have a clarification later, the people, oh, in the video she said no. Well, Dr. C, I know, but the video. So what's good about the video can sometimes be bad. The defense lawyers can take snippets of the video out of context. I mean, the Rodney King acquittal in the 1990s was largely attributed to the defense lawyers taking the video out of context and making specious arguments about little snippets of the video, much to the confusion of the jury, and the guy was acquitted, or they were acquitted. When they were beating some guy who's face down with sticks. But you can do that with video. You can chop it up into little parts and argue every little thing. You can play it over and over and over. So Defense lawyers can exaggerate things, including interviewer error. When interviewers make a mistake and it's on video, it's compelling, just like the kid's story is compelling. Seeing the interviewer ask a leading question, the defense lawyer rewinding it, playing it over, rewinding it, look at it here, let me show you one more time. See that? Putting words in the child's mind. So one of the arguments against is it can exaggerate interviewer error. These errors are not that big a deal most of the time. But because it's on video, because the defense can play it back and forth, it can be exaggerated. One of the more persuasive arguments is these videos simply document what the kid said today. Today being the day the kid was interviewed. Disclosure is a process. Kids don't tell the whole story the day we brought them to the Child Advocacy Center. Ever. They never tell the whole story that day. They might tell central parts of the story, big parts, but never the whole story. So you're only getting a piece of the story. And again, it's about exaggeration or overemphasizing. As Professor Myers argues, videotaping everything that children say is not possible, nor is it desirable. So, some would argue that videotaping is not a good thing. It could cause stage fright. It could. I always worried about that. We never told the kids that we were video recording them early in my career. Then I learned about finding words and I embraced their philosophy. They recommend telling, and we do tell. I worried about the kids acting for the camera, playing up to the camera, being scared of the camera, right? Being intimidated by the camera. The best thing about video was you got to see the kid's personality. If you tell them the camera's there, they're going to act differently. I don't want that. I want to get the real kid. You know what, though? Much ado about nothing. Much ado about nothing. Some kid, might it affect them a little bit? Maybe. I haven't seen it. Most kids, you tell them it's there, they go, okay. And they forget about it in 30 seconds. Especially now, we're living in a world where everything's video recorded. You can't even go to the bank, you go to the store, you go to walk around Montclair State. Wherever you go, you're on video. So maybe it's more accepted than it was even in the 90s. But more importantly, there's no evidence of stage fright. No evidence that it impacts at all. They just see it, then it goes in one ear and out the other, and they are as animated and as expressive as they were before we told them about video. Nevertheless, it's a legitimate issue when you say, what are the cons? What are the potential bad things about video recording? Videotapes may fall into the wrong hands. Yes, that could happen. I was going to say, well, you need to not let that happen. But that is a problem. If you don't do it correctly, the defense lawyer can give it to the suspect can give it to his friend. Who knows what might happen to the video? It's a very private statement about private things that we're documenting in the most compelling way. Yes?
You said at one point that the suspect may be more apt to disclose that he actually did commit the crime.
They might be more likely to confess.
So is it standard that the suspect does see the video?
Well, the fact that they might be more likely to confess was a positive. I'm talking about the negatives now, just so everyone's clear. You went back to the positives, but you raised the question that was on your mind, and that is, do they see it? Well, we very rarely show them the video during the investigative phase, like I told you about the 14-year-old girl on the phone in the closet. The right protocol, and you heard my lectures on investigative protocol, would be, and in this case, it's the old and out. Everybody comes to our offices. Now, she wouldn't be recorded because she's 14, but let's say she was under 12. Most of the time, the guy's there, we still don't show him the video. Only if the detective thinks that it might sway him. We might show him a snippet. But That's rare, not rare, but it's not often, not very often that we get that sense. Well, we've done it many times in my career. You want to see? Show them a clip. In answer to your question, though, ultimately, every defendant sees the video. It's part of discovery. We're going to put that in court so that the jury says that he molested a kid and we want him to go to jail for 20 to 40 years. He got a right to see what we're going to use against him, right, under the Sixth Amendment. So yeah, he'll get that. Now, we try not to deliver that right away because we know that it might fall in the wrong hands. It's very compelling. We don't want him to misuse it. We just don't want that in the stream of commerce for the reasons that Myers brings up as a negative. It might fall into the wrong hands. So what we tend to do is give them all the paper discovery, the reports, the documents, a summary of that video. But some lawyers, especially the expensive ones, fancy lawyers, they're not stupid. They see it. They go, where's the video? Well, when this thing's going to be a trial, we'll give it to you. I want the video now. He'll get it now. He's got a right to it now. I want to watch it with my client at the jail. Some guys who aren't fancy or expensive or combative, as I suggest by my tone in that description of how things sometimes work, some guys might be, Joe, I'm going to show my guy the video, man, because I think this happened. I feel bad for the kid. I want him to plead out. He won't plead. Can you give me the video? And we'll give him the video. But we try to wait to the last minute. And in 90% of the cases, 9 out of 10 cases, they don't get the video to the last day that we know it's going to be a trial. Many guys never see the video. Many guys, because their lawyers don't ask for it and they plead guilty. And that tells me they don't need the video. They know what happened because they were there. Some guys don't want to see it. Some guys absent themselves from the courtroom. Or they look down. We were going to have a hearing this week on it and it pled out, but go ahead.
I'm curious about why you don't video. Do you never videotape kids above 12? Or are you selective about why kids above 12 may or may not be videotaped?
Well, the arguments for not recording witnesses are quickly disappearing. Excuse me. When we were using VHS tape and recording with video cassettes, you got to store all this stuff. In 1 year of you know how many witnesses law enforcement interviews, including kids between 12 and 18? Hundreds and hundreds. By the end of the year, there are thousands. We had a closet with thousands of videos of kids simply under 12 from 1992 when I instituted the policy until we moved to DVDs and then ultimately hard drives. So back in the day, the argument would have been it's a storage problem. And it would have been, and it was. With kids over 12, you don't have issues of suggestibility, you don't have issues of being misled, bad interviewer questioning, they're no more suggestible than anybody else. So all of the reasons that we like to document, they're already teenagers, all the reasons we like to document, most of the reasons we like to document are different. We now record suspect interrogations. We never did that. That's maybe the past 6 years. I was for that 15 years because that's another area where the defense lawyers suggest that we do bad things, that we mistreat suspects, just like they suggest that we did bad things with the kids, that we interview them in coercive ways. Well, neither was true, and I was of the mind, just let's show them what we do. Who cares? It's better for us. We don't have to deal with this BS. Because 3 out of 4 defendants would say we threatened them or terrorized them or beat them up or whatever. They typically don't say that right away, but when they get into the courtroom and they go on trial, then we hear that for the first time. And they're very easy to defeat those kind of statements. Because everybody who gets arrested goes to the jail, they get a shower sheet, they get photos taken of them, they get complete medical exams. So they say those kind of things. But who wants to spend a third of the trial arguing that we didn't beat the guy up? Now we record it. So we record that as well. We started doing that in the DVD age, though, not in the VHS cassette age. When we started recording suspects, and I'm giving you Passaic County's experience, we arranged for all of the municipalities to get DVD recorders. And they were only supposed to record the suspects. But now that they had a way to document witness interviews, and they were liberated from the typewriter, they recorded everybody. So, in the case in Wayne, they put that 14-year-old girl on video. They put everybody on video, because it's easier. They don't need a secretary, they don't need a stenographer. All they need is a blank DVD, and hit play or record, and go do the interview. We're moving in that direction. From a law enforcement perspective, it's not the most efficient way to get information from people. You want to control the questions, and you want to control the answers, too. Not because you want to put words in people's mouths. That's not it. But people go off, yeah, you know, when I was in college, he did it. Listen, stay focused. We're not interested. What ought to be a 40-minute interaction takes 2 hours. And people, in order to evaluate this, you got to watch it in real time. Now, you're going to make you the prosecutor or the deputy attorney general. Now, a case that has 10 paper statements that are 8 pages long, right? Q&A, they call it. Where a detective, an experienced detective, is in control of the questions and keeping out the answers that are utterly irrelevant. You have a lot of information in those 8 to 10 pages from 10 different witnesses. You can get that file and review it in 2 hours. Now, you don't want to have a mastery of it, but you'll know what the case is about, and you'll have read everything in the file. In the world of video recordings, it could take you all day because they're in real time. So if there are 10 witnesses and the average interview is 3 hours, 30 hours. 30 hours of sitting there looking at this stuff, so it's inefficient. We're going in that direction, but that's my biggest problem. But other than that, I don't really care. I think it's great. It's inefficient. You can't share the information with your colleagues that easily. Yeah, she gave a statement down at the Patterson PD. Where is it? Here it is. Give him a disc. People don't want to watch it. Sometimes it's in Spanish. You don't even know what they're saying. When it's typewritten, you have to have a translator. So the translator, you know, the detective, if they speak Spanish, doesn't matter. We have a lot of Spanish-speaking detectives. They'll say, where were you on the night of the 25th? Person will go, you know, I was on Market Street in Patterson, and the typist will type it in English. So you have an instant translation with the typical traditional statement. Not with these video interviews. They do them in Spanish, then somebody's got to translate it. Now look, in a professional, well-subsidized organization, you'd have stenographers and translators, and there'd be a whole team or pool of people who but it's the government, man. It don't work that way. We don't have people to translate this. We don't have people to transcribe this. There is no, I'm a computer geek. I love computers and gadgets. There is no software that can reliably turn speech into text. Now, having said that, there's great software that does that when you're the speaker and you're using your own software and it learns your cadence and words. I use it on there. I use it on my iPad. I use it. I'm a big speech-to-text guy. I got headphones at work. I do whole briefs. So I'm a bad typist. And I challenge anyone, here or anywhere else, I'll blow you away with my speech-to-text. No one can type better or faster than I can speak it into my computers. because I'm into it. And I've taught it. I've done the tutorials, and it knows my words and my cadence. But that's not what these things are. These are people talking over one another. They're different accents. They're voice. People are speaking fast. Nothing. If you did that, I could take, I'm recording this lecture. Say I was interviewing you for 2 hours and I had that thing in the room. I could put it through Dragon, Naturally Speaking, or even some other software program. Something would come out, but it wouldn't be good. Well, every fifth word would be messed up. But it's different from when you're speaking to type. It's just a different dynamic than conversation. So you need to pay people to listen what human ears have transcribed, even in 2012, believe it or not. You know, I used to think that closed captioning that you see on the TV for the hearing impaired, I thought computers did that. No, those are real people. They listen to Friends or whatever's on the TV and they type it up as it's happening. That is translation in real time that happens on those shows. I mean, if it's the first time the show is on. If it's a recorded show, I don't know exactly how that business works. The point is that it's done by humans, not by computers. So, there's a lot of reasons we still cling to the Q&A on paper. Courts prefer what actually happened. There's certain things we're moving towards. Kids, I put, under 12, obviously, I've been doing that since 92. Suspect interrogations. You don't have to do it, and the Supreme Court hasn't ordered it, nor has the Attorney General, but I do it. What they call photo arrays. Now on TV you see 10 people get up and say, who's the guy who mugged you? Turn sideways. They're in behind a smoked mirror. Look, number 3. I think it's number 3. I need to hear his voice. Number 3, say your name and your date of birth. Well, we don't do that anymore. You can still do it, and they do it once in a blue moon, but now we show people pictures. 12 photos. So if a lady got attacked in the parking lot of ShopRite, and we need to show her possible suspects, we'll do that by showing her, like a deck of cards, we'll deal out the photos. That I record on video. Because of the potential for suggestion. The same issues that arise in forensic interviews of children arise in these identification procedures. That we misled the witness. That we told them to focus on number 4. And we don't do that. Maybe some people do it. I don't do it. I don't know of any cops who do that. Now, I know of cops over the years who might, rode the line. They're not going to ride the line there. If a cop said, why don't you look through the dozen again? They might not have wrote that in their report when they should have. That you looked at the group twice. Now, is that the worst sin in the world? No. Could a cop, I don't know of any particular scenario like that, but I'm saying those are the things. If a cop deliberately lied, that's a different story. But that's not going to happen anymore. That's why I don't want that to happen. I put all that on video. So those things I think are important. And I think one day we'll have to put everything on video. And one day maybe they'll have software where it transcribes. That's fine with me. I think it's great. I just don't like watching these videos for hours. We had a case, Del Russo, can you review this case? It's about 3 witnesses, a guy, a lady, rape, this, that, party, sex, acquaintance rape. Okay, give me the file. I'll read it this afternoon. Municipal cops, they drop a file, and there's 11 videos in there. 11 discs. I've been spending the rest of my life helping these guys out. I spend a day and a half just watching this stuff. So that's one of the reasons why. Go ahead.
I have 2 questions. So let's say I witnessed something that happened, right? And you show me all these pictures of essentially of the people that could have done the crime or whatever, right?
Right.
Do you think that by doing that, it sort of insinuates to the witness that the person might be in those pictures?
Well, that's a great observation or a great thought. And one of the things we're compelled to say is, I need you to look at these photographs. The person may or may not be among them. Do not assume, because I gathered these photos, that there's somebody in that group that has anything to do with your case. We just want you to take a look and see. Now, do reasonable people draw an inference that why they show me these dozen people? Yeah, they do. But despite that, we emphasize that that doesn't mean they're there. And I am from the school that I believe most people are honest. They're not going to falsely point out somebody unless they're sure. That doesn't mean it doesn't happen. It does, sadly. But I think most people are honest, and they're going to want to point out the person they believe it happened to. Well, yes, that is an issue that we need to disabuse them of. We need to tell them that it's not cool to do that before the photo array. Very important to tell them that. There's about 10 things with subparts that we have to agree to them and do with them. What else?
Going back to that case we were talking about, when the court's really was sleeping.
Yes.
He didn't go after her or anything?
I don't know. I'm just giving you the thumbnail of what the detectives told me. I haven't seen the report yet, but we'll find out. So you have your pros and cons for video recording. I believe video recording is the pros substantially outweigh the cons, and most jurisdictions video record. There are a few holdouts. There were more holdouts in the 90s. Much less now. Most jurisdictions, all the New Jersey counties do. Because we were in the Supreme Court in Passaic County because one of the cons of video is video technology fails. When the Attorney General was going to argue before the Supreme Court, she contacted me and we chatted about my experience with video. And I suggested to her if there was a bumper sticker that describes technology, it would be technology fails. In other words, tell the Supreme Court that's the way it is. Listen, it's not our fault technology failed. What happened was we interviewed the kid and it didn't record. So the defense said, well, that should be thrown out then. We're like, are you kidding me, man? Why? Because it didn't happen? She immediately went down and wrote notes and wrote a report about what happened. Why? Because technology fails once in a while. You have the best technology in the world. It fails. What did we do afterwards? Was that the right thing? And we felt it was the right thing. She documented it immediately. She wrote a lengthy report about what happened during the interview. And we fixed the machine. So it didn't break the next time. The defense wanted us to interview the kid again. Not on my watch. I ain't interviewing that kid again immediately afterwards because the constable blundered, because the cops messed up, because my office messed up, because the machine broke. We're not obligated to do that. The Supreme Court agreed with us. They ruled in our favor about a year or 2 years ago. And during that case, I learned that every county had video recorders. They didn't compel us to video record. They said, we don't need to answer that question. Because the defense says they should be obligated to video record. Then there would have been a discussion like we had here, the pros and cons, before the Supreme Court. But the Supreme Court, in essence, said, it's not an issue. Every prosecutor's office in the state of New Jersey video records. Why should we even entertain that? Courts don't like answering questions that they don't need to answer. It's pretty good policy if you think about it. When you're a decider, when you're supposed to decide things. Because whenever you decide things, someone disagrees with you. So why decide things that are not before you or not relevant? Just inviting people to criticize you and argue that that influenced other decisions. It's not before us, it's not relevant, we ain't answering it. And they didn't. Okay. You read the article by Dr. FINKEL, who I told you is a big proponent of the diagnosis and treatment exception to the hearsay rule. You also heard a podcast, right? Is that in this class? Where I interviewed Martin FINKEL?
Yes.
And there's his article, Children Who Disclose Sexual Abuse, Urogenital Symptoms and Signs After Genital Contact. You had to read that a few weeks back. We discussed some of that in the podcast. But the bottom line was Martin FINKEL argues in that article that you need to listen to kids. And you need to take a history. And simply looking for evidence and DNA and doing a law enforcement investigation isn't enough. Focusing so much on trauma and the findings of trauma to the genitalia is overemphasized. You need to listen to the kids. You need to hear what they say. And sometimes they may say things that are diagnostic, arguably just as diagnostic as whether there's genital trauma. How they felt afterwards, or if it burned when they peed. You know, things that they had to say about their bodies are important, and they need to be asked. And doctors need to pay attention to those things that don't appear to be abuse specific. Like seeing if the vagina has injury is abuse specific. Everybody, well, let's take a look. Is the hymen still there? Is there injury? That's what people want to see. They think that that's how we tell. And you could, in some cases, very rare, as you learned, you could find genital trauma, but Martin argues that that's overemphasized. Instead, we place everything on that and not listen to kids. There are other indicia, other more subtle indicia of having an adult molest a child and manipulate their genitals. So that's the article that you read, and that's in large part what Martin was saying. Okay, let's get a little bit into confidentiality. As Professor Myers points out in his chapter on confidentiality, you need to have a source of confidentiality. People sometimes say, well, that's confidential. I can't share that with you. Really? That's fine. What makes you say that? What's the source of confidentiality? I don't know, it just is. Well, every assertion of confidentiality has to have a source. There are three sources of confidentiality. Three. Ethical duty of confidentiality. Ethical. Statutory. Like statutes, laws, statutory. And what are known as privileges. Okay? Now, an ethical duty of confidentiality arises from the ethics of the profession. So if you're a social worker, or you're a doctor or a nurse, these are just examples. There are many relationships where the ethics of the profession make it a violation if you reveal confidential information, a violation of ethics. So the National Association of Social Workers, if you're a member, they have many rules and many regulations besides paying them about a member in good standing. Somewhere among the description of a member in good standing is you may not disclose confidential information between yourself and a client to third parties. Now, it's probably said differently than that and better than that, but the point is, in order to be a member of the National Association of Social Workers, you have to pledge confidentiality between you and your clients. The AMA, the American Medical Association, most doctors are members of the American Medical Association, right? In their ethical guidelines, you have to maintain confidentiality. The nurses have a professional organization. The substance abuse treatment providers have professional organizations. Dentists have professional organizations. Psychologists, the APA, the American Psychological Association, has an ethical organization. If you violate confidentiality, what's the remedy? We go to jail? No. Maybe if you violate something else, but purely on the ethical, no, you get kicked out of the AMA. You get kicked out of the National Association of Social Workers. You get punished administratively. Your license gets suspended. So that's an ethical duty. Remember, these are sources of confidentiality. Ethical. The next one is statutory. That's where there's a law that makes something confidential. Where there's a law. The American Medical Association, or the NASW, the Social Workers Organization, those aren't laws. Those are private organization rules. But sometimes there are statutes that make things confidential. If you go all the way back to our first classes, you saw Title IX up there. And there were a bunch of things we looked at in Title IX when they talked about abuse and neglect. And the statute talks about exactly what abuse and neglect is, who has jurisdiction over abuse and neglect. Title IX also says that the records of the Division of Youth and Family Services are confidential. That would be a statutory source of confidentiality, where there's a law that makes records confidential. Right? So you see the difference between a statute? There's a law that says DIFUS records are confidential. There's thousands of laws making thousands of things confidential. Title 18 of the United States Code makes education records confidential. So your kids' records at school, or your records at school, in a public institution are confidential. Why? Because there's a statute that made them confidential. So, ethical, statutory, and the last thing is called privileges. Privileges. Privileges arise as a rule of evidence for litigation. Privileges are evidence rules. Privileges only matter in legal proceedings. As a source of confidentiality, privileges are relevant only in legal proceedings. And they'll make more sense if you think about how litigation works, how legal proceedings work. Generally speaking, the law is entitled to every person's testimony. You cannot, as we talked about when I discussed contempt of court last week, if you refuse to give testimony and you've been subpoenaed, they put you in jail. We talked about that. The woman in Spain and other cases. The Valerie Plume case, when the reporter would have divulged sources. So everybody has to testify. But there's an unless. And the unless is everyone must testify unless there's a privilege. And if you think about the word privilege in this way, I am privileged to not testify. That's why they're called privileges. And they're privileges is because everybody's got to testify except the very few people. Those people are privileged. They have a privilege not to testify. Examples are an attorney is privileged not to testify against his client. Okay? If we subpoena an attorney and try to get him to testify against his client or her client, he can rely on attorney-client privilege. That's a rule of confidentiality that we call a privilege because it's in the rules of evidence. And he's privileged not to testify. All other people on the planet have to testify. Not this lawyer, because the substance of what we're asking him is about what his client told him. So he's privileged. Now, that privilege has its limits. One of the defendants that I prosecuted a few years ago is represented by a lawyer. Won't tell you his name, but the lawyer went to the judge and communicated what the client told him in confidence last week. And communicated it to me. Why? Because the lawyer learned from the client that he's going to have me and the judge killed. Now that's an active, open investigation. That is a confidence of a future crime. It ain't privileged. The lawyer did the right thing. Thank God, right? Confiding in a privileged person a future crime ain't privileged. So that's an exception to privilege. But generally speaking, lawyers are not supposed to betray their own clients. There used to be something called priest-penitent privilege. It's been broadened. In many places it's called cleric or spiritual advisor privilege. And it says that in a religious context, a person who seeks spiritual counseling or confession from a religious person the person does not have to testify about what they said, and the priest or rabbi or imam or whomever, the religious person, spiritual advisor, does not have to betray their parishioner or their client, their church member. They're privileged. That's confidential. Can someone tell me another example of a court privilege? Go ahead.
How about a psychologist?
Psychologists and patients have privileges that are protected. That's true. Go ahead.
I was going to say, there's a really good book, called The True Story of Professional Privilege and Serial Murder about a psychologist who had a serial killer patient. And it was actually the Greenwich Village murders in New York, I believe, from the 1960s. I actually read the book. It's really good. The patient basically describes the killings in detail, but he can't say anything because it already happened once he's describing, and he's not talking about any future. But it goes on to basically the guy ends up kidnapping his fiance, and he has to figure out what to do. But he ends up just getting his fiance back, and he can't say anything.
Yeah, that's a good example of the dilemma and how difficult it is for many professionals. Depending upon what the man said, the serial killer, as long as he didn't confide a future crime or future harm, you don't have to tell.
Spousal?
Spousal privilege. Spousal privilege. A husband cannot be compelled to testify against a wife, nor can a wife be compelled to testify against a husband. Spousal privilege. It used to be that the husband can invoke the privilege on behalf of the wife. For example, if the wife wanted to testify against the husband, he said, "No, I'm not letting you. I'm invoking spousal privilege." Even though she wanted to, you, as the defendant, could squelch the testimony of your wife and vice versa. They've changed that. If the spouse wants to testify, then they're allowed. But if the spouse says, "I don't want to testify against my husband," it will not happen. Spousal privilege. Go ahead.
What about the doctor?
Doctor-patient privilege, very good. Psychiatrists, medical doctors, all doctors. Go ahead.
How about parent-child?
No. No, you can get brothers and sisters and moms and dads to compel them to testify against their kids. Interesting one, but it doesn't exist. Go ahead.
I got a question. How about if the client is someone that abuses children and is presently abusing children, and every time he comes to the therapist or the psychologist tells them about a new child? Would that
Yes,
be a
hold that thought.
situation?
Yes, it would be. That'd be an exception, and I'll tell you why. the reason why these privileges exist and this confidentiality exists is because all of these relationships, doctor-patient, husband-wife, attorney-client, every one of them rely upon what? Trust. Every one of them. You cannot be a good doctor or psychologist or spouse or priest if your client, this client, and future clients don't trust you. You can't help these people. And you can't help future people. So the rationale is that if you protect confidentiality, other people will get help, other people will confess, other people will do the right thing. And that's a good. But there are exceptions. Future crime's an exception. We'll get to your example in a minute. Tarasov versus the Board of Regents of the University of California. Fascinating case. It's among your readings. That was where some kid out at UCLA, I think it was the 70s or the 60s, was fascinated with some girl. Her name was Tatiana. He had no interest. She had no interest in him. And he told his therapist that he was going to kill her. And the therapist didn't take meaningful action. How much action he took and whether he did the right thing. He notified the campus police. They didn't do much. And the guy wound up killing Tatiana. The parents, Tatiana's parents, sued the University of California. They sued the Board of Regents. They sued the doctor. They sued the police. And they said, you should have told us. You should have warned us. You should have warned my daughter. And the school said, confidentiality. Doctor-patient, psychologist-patient. And the court of the Supreme Court of California eventually ruled, back when they were a court that had respect and was influential, the Supreme Court of California said, in certain cases there's a duty to warn of future harm. And many cases adopted that rationale. And many states either passed laws or had court cases that adopted that rationale. It's changed and gotten different over the years. So essentially the way it operates now, the duty to warn, is as follows. There has to be a credible threat of imminent, serious harm to a readily identifiable person. So let's deconstruct that. Credible threat, go to number 1. Imminent harm, number 2. Serious harm, number 3. Readily identifiable victim, number 4. If any one of those elements are missing, you don't have a duty to warn. So, to give you an example, a man in therapy says, I used to be married to a blonde. I can't stand blondes. I'm going to kill a blonde in one of these malls in northern New Jersey. That's what I'm going to do. Well, let's see. Credible threat? We don't know. Did I say that number 1, credible?
Yes.
Yeah. Credible threat? Let's assume it is. Serious harm? You're going to kill somebody, pretty serious to me. Imminent? I'll change the facts. I think I said in the next month. Imminent? Well, I think imminent, 30 days is imminent, right? If you say, I don't know, on the moon, when the moon passes Jupiter, 10 years from now, different. Imminent? Yeah. Readily identifiable victim? No. Right? I'm going to kill a blonde in a Northern New Jersey Mall? Who are you going to warn? Well, this ain't TV where we set up a, the police set up, we find out all 30 malls in Northern New Jersey and we set up and the answer is no. Now, a lot of people say, oh, I'm going to kill somebody, but if the therapist doesn't think it's sincere, they don't have to warn. You could say, and it could be credible, I was dumped by a blonde, and I'm going to go find this blonde I know, her name is Nikita. In 5 minutes, I'm going to track her down, I'm going to smack her. Right after I leave this session, I'm going to smack her. You got everything but serious harm, right? You need serious harm. Serious harm. There's no duty to warn about trivial harm. So those are the elements. Credible threat, serious harm, imminent harm, readily identifiable victim. Then you got a duty to warn. Go ahead.
What exactly is a credible threat? Is that like how sincere they are when you're saying it?
Yes. It all depends. Therapists know. Doesn't mean they're right, but you know. You got brothers or sisters? How many about? One sister? Yeah. You know your sister. If your sister goes, I'm going to pull my hair out if they don't put Desperate Housewives back on the TV. She going to pull her hair?
It's like their first session or something.
Well, then they are on the side of credible, right? I mean, you got to make a call. The point is, they may have many sessions, and they may hear a statement, and may say it's not credible. So it's a judgment call. Simple as that. Like I said, you know your sister, right? She makes a statement. She didn't say, I'm going to kill somebody. And then later something comes out bad, and then you go, well, I know my sister. She'd never do something like that. Relax. She didn't mean it. That ain't her. You could be wrong, but you're in the best position to judge whether that is. So it's a very judgment call. Arguably, you should err on the side of caution, right? Some people so know their clients that they know, the guy's going to hurt a fly. Any other questions about that? Okay, we started almost on time. I want to take 5 minutes. I want to go get a drink and come back, take a breath, stretch, and then we're going to begin. We got a little bit of catching up to do the next 2 sessions.
Can you talk about what the therapist says?
Okay, let's pick up again where we left off. We were talking about confidentiality in a variety of different contexts, and one of the issues raised was whether a therapist or any person who is in a confidential relationship has to maintain confidentiality if they learn from a client that that client was intending on abusing a child. And the answer is no, they need to report that. Mandatory reporting, which we talked about earlier in the year, mandatory reporting overrides confidentiality. Always, every time. Now, State versus Snell, the court case that you read for today's class, or for this learning module, looks at the limits of mandatory reporting and what that information can be used for. You see, Snell, I think he molested his grandkids. In any event, he confided in his psychologist, I think it was a psychiatrist, Dr. Torrance, that he molested his grandkids. And that psychiatrist reported it to the Division of Youth and Family Services, the Child Protection. Why? Because mandatory reporting, the protection of children, overrides confidentiality. So he did the right thing. Then the prosecutor tried to subpoena him in a criminal case to testify against Snell. So, to say it one more time, the prosecutor subpoenaed Dr. Torrance to testify against his client. And the prosecutor wanted Dr. Torrance to say, yeah, I was in therapy, and that guy sitting here, he told me he molested his 2 grandkids. He molested them in the barn, and he molested them in their room, and he licked them, and whatever he did. He wouldn't do it. He moved to quash the subpoena. Dr. Torrance said, I don't think I should be forced to testify. And the appellate division ruled, you're not going to have to testify. So, you are mandated to tell DYFS. DYFS is mandated to tell the prosecutor. But the prosecutor cannot compel the confidential relationship person, the professional in a confidential relationship. The prosecutor can't compel them to be a witness against their client. Now, the prosecutor can use that information to build a case. They can go interview the kids and interview the grandma and try to get medical evidence and go to the scene of the crime. They can open a case. It's not fruit of the poisonous tree to take that information and go looking to see if you can prove a case, but you cannot convict the client through the words of the professional. Yes?
Out of curiosity, like let's say, like a psychologist was confided in and said that helping with the grandparent was mostly his grandchildren or whatever. After that, can he still treat that patient?
Sure, in many cases he would. I mean, if the patient doesn't want to be treated anymore, many professionals tell clients right up front what the limits of their relationship are. In fact, all professionals who are part of the APA or professional, they say, look, what you tell me is between us and only us. This is confidential. But there's certain things I have to do that I have no control over. If you tell me you're going to hurt somebody in the future, then I have to tell the authorities. If you tell me that you molested a child, anytime, I have to tell the authorities. There are limits to what's private. But other than those things, everything else is private. So, I don't know whether that guy is going to continue to want to go to that doctor, but he could. No reason why he shouldn't. Is there a reason you think that he should or couldn't?
I just didn't know if there was some sort of law that like once you report it.
No.
And if you do report it, is it like anonymous if you're a therapist, or if something's kind of obvious, right? So.
Well, yeah, because you have to give some facts, and it might be obvious. But many professionals do report anonymously. I got no respect for them, but they do. The statute allows anonymous reporting, but that's to protect people that live in a community. In my view, you want to report your neighbor, but you don't want to. You're a teacher or a doctor, and you work with kids. You got to hide behind anonymity, which makes the case harder to prove and harder to protect the kids and harder to protect future kids because you want to hide behind anonymity. Don't work with kids. You won't have to do it. That's what I got to say. But they do it sometimes. But again, you could figure them out eventually. Obviously, members of the treatment team, if you go to the doctor's office and a person comes to take your blood pressure and you're saying, oh, my elbow hurts a real lot, I think I heard it when I lifted this thing, that person is in a confidential relationship with you. They are an agent of the doctor. So what you tell the first staff member that encounters you at the doctor's office, it's confidential. Members of the hospital treatment team, the doctor's treatment team, those are confidential discussions. A subpoena does not override confidentiality. A subpoena is a document that lawyers give to people for legal proceedings. You may have to go to a deposition to tell information that's related to a civil lawsuit. Or you may have to testify in the criminal courts or the juvenile courts or the family court. Just because a person receives a subpoena doesn't mean they must answer it if it asks for confidential information. Excuse me. Mandatory reporting of child abuse overrides confidentiality. Subpoenas do not override confidentiality. There has to be an exception. And it's best advice, if you're in a confidential relationship, you're a psychologist or a dialysis worker or whomever, you get a subpoena, is talk to your attorney or a attorney. Up on the big board is HIPAA. Now, HIPAA is an acronym for the Health Insurance Portability and Accountability Act, first passed by Congress in 1996 and amended in 2002. And essentially, it emphasizes and makes clear, although they used to be, but it makes clear and expands confidentiality of our private health records. So HIPAA is about health records versus what we tell our doctors, the paperwork that surrounds our health. Now, when this first was amended in 2002, the health industry was obsessed with HIPAA. Everywhere I went, there was forms about HIPAA, questions about HIPAA. I can't tell you that. What time's the doctor's office closed? I can't tell you that. That's HIPAA. Do you even know what HIPAA is? Well, it's an important guarantee of confidentiality, but there are many exceptions. In the world of child advocacy and protecting kids, it is not something that undermines our ability to do good investigations. One of the exceptions is law enforcement can get protected health information, certainly with a subpoena. If it's mandatory reporting, it's an exception to HIPAA. A judge can order exceptions to HIPAA. If you're a victim of crime, you can get your records and other records. And one thing you need to understand about confidentiality that a lot of people really don't get, it can be waived. The person who's protected by confidentiality can waive it. So when I say will, the prosecutor's office will call a doctor or call a psychologist or call a school principal and want to get records, and they'll refuse to give them to us. And appropriately, they cite Title 18 or some other statute or some other administrative regulation. And we'll say, listen, we're investigating on behalf of the child. She wants the records. Oh, you can't give them to me? You have a waiver. Who are you protected? It's the law. In all cases, a waiver, other than some privileges, a waiver overrides confidentiality. Makes sense, doesn't it? If confidentiality is there to protect me and my privacy, if I waive that privacy, then the records should be available, and they are available. But some professionals don't get that. Go ahead.
Does there need to be proof that the child wants the records? Like if the investigator just says the child wants this information?
Well, the child is not the right way to express it. The child's parent makes those decisions.
Does that have to be proven to the person they want to get it from?
Well, we give them a waiver. We don't simply say it on the phone. They sign on a piece of paper, and we give it to them. We give them a written waiver. So to that extent, It doesn't have to be proven. I can call on the phone, and if they believe me, then it's a waiver. If it's true, it's true. You know, everything in the world doesn't have to be proven. It just has to be real and true. But 99% of people use a written waiver because ultimately somebody says we didn't give a waiver, now we got proof. So we typically use a written waiver. Sometimes they're not impressed by that. They want a subpoena. They just don't get it. I make up subpoenas on my computer, man. Lawyers have big books of that. They buy on Main Street, Patterson. There's nothing magical about a subpoena. They're issued by lawyers. It's got a formidable word. It's got big old English font on it. Scary. So they'll say, oh, no, don't send the waiver. I'm not giving you the records. If you give me a subpoena, I'll give you. Oh, you want a subpoena? Do you want a red ribbon on it? Do you want a big brown stamp that says confidential? I mean, I'm being silly here because these things get under my craw, but the perception is that a subpoena is more potent than a waiver. It's not. It's not. Subpoenas are simply a lawyer's demand for information in contemplation of a lawsuit. But for whatever reasons, the notion of subpoena, people's perception of what a subpoena is more serious than it really is. But you want a subpoena, you'll get a subpoena. No problem with that. I'll get you a subpoena. Go ahead.
It has something to do with the judge. With the judge.
Well, I'm overstating it a bit. Yeah, we issue subpoenas in the name of the court. I can't subpoena, women's phone numbers. I'll go to jail, right? That wouldn't be good, right? Because I am subpoenaing things with certain representations. Number one, there's a future legal proceeding that I'm gathering information about, and I'm doing this in the name of the court. Subpoenas are done in the name of the court. If you are a fraud, or if you're subpoenaing for personal benefit, you could be kicked out of lawyering and kicked out of the profession and go to jail. And so yes, the court, but the court doesn't get involved in it. So that's where it's a bit of a disconnect. You're doing it in the name of the court, but they don't get involved.
It's only if they find out.
No, they're allowed to, if they find out you did something wrong. They don't need to find out. You are entrusted as a member of the bar to compel witnesses in anticipation of litigation in the name of the court. So it's as if the court's subpoenaing you. And that's why I think people are more impressed with it, because you do it in the name of the court, but the lawyer signs it. But if you look closely, it's clear that the lawyer's the one asking. But it does look, ye are commanded to appear at the county court of Passaic in 9 o'clock in the forenoon. Failure to show at the appointed time will expose you to contempt of court and incarceration until the contempt is purged and vitiated. My God, I better go to court.
So for certain things, like let's say you wanted to get like telephone numbers from Verizon or something, like in some sort of case that you're involved in, do you need like special permission from a judge in order to do that, or it's just?
No, there are certain things that are protected under the Wiretap Act and by other statutes. I'm telling you that a subpoena doesn't override confidentiality. So our phone numbers, our conversations with people on the telephone, our emails to one another, communications, the government can't get without court orders. A subpoena alone doesn't apply in every case. I'm telling you that a waiver works always, but some professionals aren't impressed, so they want a subpoena. And I'm suggesting to you that a subpoena is a weak document, not a faulty document. It is legitimate, but weak. It's solely the perception of the lawyer that allows its authority. Now, if you use a subpoena knowing full well it's a gain for your own benefit, that's criminal. But if you just use a subpoena and you're wrong, you go, I don't care about confidentiality, I never heard of that. You got to give me the record. They go, oh, okay, I'll give you the records. You don't get in trouble for that. It could have been wrongly issued because a subpoena doesn't override confidentiality. And your Verizon phone records are covered by the Wiretap Act and other statutes. They're generally confidential. Go ahead. You have a question?
No.
Oh. Anyway, those are some of the issues of confidentiality. A waiver is always effective, should be always effective in vitiating any confidentiality and taking away confidentiality, because the person protected has given their permission to share their personal information. Now, does everyone follow confidentiality? Does everyone respect confidentiality? No. And I think I have a couple of video clips that are pretty close to what really happens. While that's going up here, remember I talked about privileges? Here's a privilege for victim counselors. Remember we all said, hey, psychologists have a privilege not to testify, certain cases. Doctors. Well, the legislature concluded about 20 years ago, you know what? Some victims, they can't afford doctors and psychologists and psychiatrists to go to after they get mugged or raped or beaten. And they need therapy. Sometimes they just go to somebody who's a master's in social work, or a bachelor's, or just a spiritual counselor. But they're seeking counseling because they've been a victim of a crime. They're privileged if you meet these criteria. You're going to the counselor because you're a victim, and the counselor has had 40 hours of specialized training in treating victims of crime. So you have to be going to the counselor because you're a victim of a crime. And the counselor has to have 40 hours of victim counselor training. And there's a couple other definitions in there as well.
You tell us.
Okay, here's a clip from a pharmacy. Pay attention to what's confidential and what isn't confidential, if anything is confidential.
I don't see.
You tell us.
I don't see anything for David Moore. Can I see that chart again? $112, no copay. Here we go, $112 for Joan Moore. First time prescription for Selegiline.
What's that for?
Depression, among other things. You'd have to ask her doctor, Dr. Richard Shipman. Right around the corner on 93rd.
So two cops go to a pharmacy to get information about a person. Imagine that person's you. You have an account at the pharmacy. Your insurance card's there. They walk up to the pharmacist or the pharmacist's helper, and they ask a bunch of questions. And that's you they're asking about. Did they invade your privacy and give out confidential information to that lady?
Yes.
Well, give me 3 pieces of confidential information she gave away.
She's on depression. She's on depression.
Well, hold on before the depression. That she's even
Yeah.
known to them.
Yeah, that that she bought stuff from them.
She is a patron of that pharmacy, number one. She's getting medicine from that pharmacy, number two. The name of the medicine,
What it's used
number three. What it's used for, and who her private physician is. I got 5. And his address.
Was that a refill?
You tell us.
Let's watch it one more time and listen. And they're cool. They're like, well, you tell us. Like, they act like they know information. That's how they get people to work with them. But they don't know. They just got some basic information.
You tell us.
I don't see anything for David Moore. Can I see that charge again? $112, no copay. Here we go, $112 for Joan Moore. First time prescription for Selegiline.
What's that for?
Depression, among other things. You'd have to ask her doctor, Dr. Richard Shipman. Right around the corner on 93rd.
So now the detectives go to the doctor around the corner on 93rd. And here's what happens.
You can't tell us why you might have prescribed Selegiline for her?
How about any going to confirm whether or not she's a patient? I wish I could. I'm sorry, doctor-patient privilege.
Well, her privileges have been suspended, Doc. She's lying in a coma at Stein Memorial.
What? How did that happen?
Well, so she is a patient.
She got an insulin overdose from an injection. My God.
This drug you were giving her, was it for depression?
That's it. We're done. I have a patient to need me. Don't forget about the one in a coma.
This is going very well.
So these are very real-world issues, as you can see. I mean, these are examples from Law and Order, but it's well done. I mean, that's what happens in the real world. People give out information that they shouldn't sometimes, and some professionals do live up to their responsibilities and refuse to give information. Now, what made this interesting, I guess, and what made it good TV is that, you know, many people identify with the police officers, like the lady's in a coma. The cops are okay. The doctor's a jerk, you know, and they're acting like the doctor's a jerk, and they're cracking wise with him, you know. And it's confrontational. Now, the remedy here is, now I don't know I don't even remember anything about the story of this episode. Who's against them, who's for them. I suspect that they can't get a waiver, but they may be able to get a subpoena, even a court order. But when you're in the field and you're going from fact to fact to fact, that's a little bit of work. Certainly getting a judge and writing an affidavit, it's a lot easier to try to get the doctor to give you the info on the QT privately, violate confidentiality. But that doctor handled it professionally, wouldn't do it. Any questions about what we talked about today? Okay, very good. Since we started early and we had a short break, we can leave a little bit early, and I'll see you next. Even though we could start on the next learning module, we won't, and we'll do it all next Wednesday. And I'll talk a little bit about the exam as well next week. What to expect. I may even do something I rarely do. No study guide. Come on. No. But I'll go over subject areas with you.